Okay, hello everybody. Thank you for joining us. We are producing this quick update, or shall we say an overview for you. And this is aimed at, well, the subject matter is fairly clear, looking at preparations for dismissing a director and a general overview. My name is Lee Stevens. I'm a director at Bridge Employment Law, a specialist employment law team, and this is...
My name's David Rogers. Hello everyone, I'm a director at Bridge as well.
So this is aimed at, for our clients and our connections as well, primarily HR managers, directors, and director/managers who are handling or preparing for the removal of a senior exec or director. And what David and I want to do today is just to talk through the preparation and planning phases and the things you need to think about to get this sort of situation prepared for, considered properly, and lined up before you then go ahead and take action. We deal with a lot of these situations for clients, so we're fairly familiar with them. And if you do need to contact us and you want confidential pre-initial consultation call on this kind of subject, then David and I deal with that, and you can get in touch with us on the details on the slide there. Okay, so starting off, I think it's me kicking off first. So what are we looking at for you today? So removing a director, we said, and so the structure of the talk is the key things you need to consider. So how to plan and prepare, and we'll look at the commercial planning first. So that's the practical considerations, and then the legal planning as well. So moving on to the next slide. So commercial planning, I'm sure David will chip in if, from your experience, David, as well, you want to add anything.
Yeah.
So first of all, most clients, when they come to us, want to assess the timing and look at the impact and disruption. So the sort of questions that you need to consider here are, look, how quick can we move? Well, that depends, and move as in remove the individual. That really depends, as we'll see on the later slides, on your contractual terms with the individual. So how long have they been with you? If they've been with you under a couple of years, well, we know there's a lot more flexibility there. But for senior executives, you still need to be looking at the contractual terms, which we'll go into shortly. What are the notice provisions? What are the legal obligations there? Significant problems can occur when clients move too quickly to remove somebody and they erode their legal position, as we'll look at later. Also, in terms of planning and commercial planning phases, what about your interests? So as on the slide there, our customers, our staff, and our systems and compliance. So there needs to be really a risk assessment at a senior level as to what impact this individual's removal from the business will have. So could they take customers? Are we protected? We're going to look at that shortly. Could they disrupt staff or present projects, or take work or take staff? How are we protected there? And what about our systems? What have they got access to? Social media accounts, marketing accounts, to finance, to confidential information, trade secrets. And maybe there's even some compliance issues. Some businesses we work with that are regulated in certain sectors can't remove an individual because they're designated for various compliance reasons to particular types of services or contracts, and we need to handle that as well. So again, that's just a flavor of the sort of initial considerations that we start to talk through with clients when we're looking at planning these exits. Also assessing confidentiality and competitive restrictions. So I mentioned that earlier on there. Removing someone senior if they have a supplier, client, or their facing role, or they're integral in terms of leadership in your operational team, can pose a number of obvious threats. So what does your contract say? Have you got restrictions in place? Again, we'll flag that later on. That has to be part of your immediate assessment. Another practical sort of commercial consideration is the PR sort of optics of the whole issue and commercial consideration. So I mentioned earlier, is this person integral to particular contracts or to your ability to satisfy certain compliance requirements? That all needs checking. What about the PR of the situation? If it's a dismissal or an exit under conduct reasons, we'll look at the reasons later. say perhaps gross misconduct, how is that going to affect you? Do you want that getting out in the public domain? Will it have an adverse effect on the business's reputation, funding, finance, compliance, etc.? All that needs to be planned and managed. And as we'll look at later, there are ways of going through what you might say is a formal process or an informal, more commercial negotiated exit, the latter being perhaps more controlled to manage those sorts of considerations and risks. Finally, just again, a flavour of the things that we often look at, are we replacing? Well, if we are replacing, then that will mean certain bases for removal won't be available to you, for example, like redundancy. But also you might need to do that in a certain way. It may need to be negotiated through settlement agreement terms. We'll look at that later, so that you can manage that exit quickly and also bring someone alongside and hand things over as well. So again, practical considerations need to be thought through there as well. So on to the next slide for David, I think.
Yeah, I just want to quickly look at some of the wider, not necessarily legal, but wider, more commercial considerations and practical considerations that need to be looked at as well when you're looking at exiting a director. First one we've got on the slide is regulatory and or customer reporting requirements. And just by way of example, if it's a financial services business that we're talking about, there are requirements that you need to report to the FCA certain matters. For example, and it depends largely upon the reason for the termination. But if it's, for example, a conduct issue that relates to fitness or propriety, then there are strict regulatory requirements that these matters have to be reported to the FCA. So things like that need to be looked at in that situation. Another example would be care homes. And again, there are strict conduct requirements. There are strict rules where you need to report certain matters to the CQC. So again, depending upon the reason for termination, that might be relevant. Again, this sort of touches a bit on one of the points that Lee made. I think that you made, for example, care homes is a good example. You may have a manager who's got to be registered as a registered manager. If they're removed, then that can cause impact on the business if you don't have a new registered manager lined up who's qualified to take their position. So those sort of practical considerations need to be thought through in advance, because it's too late to do it after the event. Once you've already pulled the trigger on a dismissal, it's too late to then say, well, we haven't got this in place. You need to have it all lined up ready in advance. Banking and finance, again, just practical things like bank mandates. Is the director a signatory of the bank mandate? If so, they're going to need to be removed from that prior to, or at least on termination. And you'll need to make sure that you've got new signatories in place if they're needed, if you don't have sufficient. Similarly, there may be loans in place. There may be directors' guarantees in place in relation to not just the bank, but also in relation to commercial arrangements. So, for example, leases. If you've got properties that are leased, it's not uncommon for, particularly with smaller businesses, for them to require personal guarantees, and it's often the directors that are the guarantors in relation to those arrangements. So that needs to be looked at as well. But you may think, well, that's more of an issue for the director than themselves, and it is, because obviously if they're left on as a personal guarantor to a lease, that's a problem for them. But it's also potentially a problem for the business in terms of the relationship with the landlord potentially, and also the director is likely to be aware of it. So they're likely to insist upon that as one of the, if you're looking to negotiate an exit, which is often, and we'll come on to talking about settlement agreements later, but often with directors, a negotiated exit is the most sensible way forwards, and they're always going to want to remove all those any personal guarantees that they have in place as a condition of signing any settlement agreement. So you need to make sure that you have somebody else lined up, because it may be that the landlord, or if we're talking about a bank loan, whichever arrangement we're talking about, they're likely to insist upon an alternative guarantor being put in place, and that may not be easy to arrange at short notice for obvious reasons, because we're talking about personal liability. Directors and officers cover is also mentioned on the slide. Again, most businesses will have this in place for the directors, but not necessarily all. And again, it's the sort of issue that it's more of an issue for the director, the personal director themselves, rather than the business. But it becomes a business issue if it then becomes a sticking point in terms of negotiating the exit, because this type of policy, directors and officers cover, essentially covers personal liability for any directors who were pursued via a legal claim, and it could be any number of things. It could be health and safety issues. It could be failure to report. It could be regulatory requirements. But if there is any personal liability, the D&O cover should cover individual directors. And again, whilst that is an issue for the individual director, it's also an issue for the company if the director says, well, I'm not prepared to sign anything unless I have sight of the D&O cover. And importantly, that I've got confirmation under the settlement agreement that there's a run-off period and that I'm covered for the next typically 6 years, which covers them for the risk period that they're likely to be potentially on the hook for any liabilities. So that needs to be, if it's not in place, it needs to be thought about in advance, because it can become a sticking point. Data, equipment and systems, again, we're talking about practical issues here, really. So particular directors tend to have access to lots of data and systems, and often, because they're in trusted positions, they're the only person in the business who's got that access. And it's easy to forget that if they suddenly leave and it's not planned, that you may have difficulties in accessing that information and certain systems. But by way of example, just company's house filing is a good example, I think. There are access codes known as authentication codes, which you need in order to file documents at company's house. It's effectively a means of, it's the equivalent of an electronic signature for the company. And if you don't have those authentication codes, you can't do the filing that needs to be done at company's house. I've seen it before. It's a thing that's often forgotten. One person has access to them. Nobody knows where they are. They've left, often under a cloud, and aren't necessarily going to be cooperative in providing those codes. So that's something that needs to be thought about as well. So just a few practical examples really that need to be thought through before you look at terminating.
Yeah, that is worth noting as well. I think David and I discussed recently that D&O cover can potentially save the business cost if the individual is named as a respondent to a claim after they've left as well. So it can be mutually beneficial. And these things, whilst David's just rattled through them, we've seen these things cause quite major problems in post-exit or having not been dealt with as part of the deal, and can be real problems if they're not thought through in advance. So well worth noting. Thank you, David. And then on to the next slide. We've just produced, this is just an example of a table, again, that David and I might, sort of a type of table we might send to our clients to say, look, if we're preparing this, and remember, something I should mention here as well for those of you who are practicing sort of HR directors, managers, and or generally managing these situations in the business. This sort of stuff, if it's been passed around prior to the exit, is evidence. It needs to be dealt with by solicitors so that we can rely potentially on legal privilege so that this sort of stuff isn't disclosed. So when our clients get in touch with us and give us these instructions, we'll often prepare this sort of documentation so they can start engaging with us and giving us this type of information to cover all these bases and plan the exit and the strategy. If you start doing that between yourselves and the person puts a data subject access request in and starts getting a bit tricky in negotiations, this sort of stuff can bite you on the backside later. So just bear that in mind. But if you have a little look at this on the slide, or if anybody wants a copy of this, or you need any additional help, get in touch. Just things in terms of preparatory documentation, service agreements and side letters. Remember, it's not just what's in the service agreement. There could be memorandums or letters promising other things that they may rely on. Handbook can still apply because a director is not only a director statutorily, but also as an employee. So what provisions are in there that they could rely on exit? We need to look at that. Articles of association, shareholders agreements to deal with the process of removing directorship and or the equity interests, if there are any, or any equity on option schemes, share certificates if there is equity, pension details, benefits, insurance, pay, bonus terms, things that David covered, mandates, lease, finances, banking, all that sort of stuff, and access to systems needs to be accounted for. And it's well worth producing a list of everything they've kind of got into, got control over, or are involved in, so that we can work our way through systematically. So once we've got a plan, we know we've looked at the whole playing field, we know what's on it, and we know how we're going to deal with it to avoid issues later on. So on to the next slide. I think it's me next, isn't it?
I think so.
Yeah, okay. So check contract terms and remember the dual roles. Well, I've already mentioned that. So we're not only dealing with an employee, we're also dealing with a director. And David's going to cover just highlight some key points to note around removing the directorship later on. But once we've looked at our commercial and practical considerations, we want to get under the bonnet legally and look at the legal considerations. The first things we look at there are obviously the contractual terms, because they're going to regulate the basis upon which we can remove somebody, and just things like, for example, so how do the notice provisions work? These are extremely important, and the contract's important. Before I go into this, for another big reason, we don't want to breach it, because if we do breach it, we won't be able to rely on it. So, for example, if we do something that is deemed a breach of contract, we may not be able to rely on that contract to enforce our post-termination restrictions. So if we've got a director, a senior exec who are often involved in commercially sensitive information, classic example would be a sales director who knows all your customers, suppliers. We breach the obligations in the contract fundamentally on handling the exit. Let's say we don't give them the appropriate notice, or that we don't pay them a bonus, or we fundamentally breach our obligations, then they're going to be able to argue breach. They're going to be able to argue that we can't rely on those contractual terms that protect our business later. So it's vital that we look at the contract, examine it, and all the peripheral promises and commitments in handbook or letters or elsewhere to make sure we know what the rules are. So is there a garden leave provision in there? That can be useful for sending someone home, keeping them away from customers, suppliers and staff, because they're still employed and we're still paying them during that period. And if you don't have any valid or useful restrictions that will apply post-exit, and you can't negotiate to put some in a settlement agreement, which we'll go into later, garden leave can be quite useful to give you that breathing space to get somebody out of the business. But of course, you've got to have a legal basis to give them garden leave and notice first, remember. So we'll be looking at that shortly. Payment in lieu of notice, you've got to handle that carefully. It needs to be drafted carefully, but are we able to pay in lieu? You can't pay in lieu unless you've got a contractual right to do so. Just bear that in mind, or you agree to do so, otherwise you might have a breach. If you are putting someone on payment in lieu of notice provision, are there things like phased payments in there? Is it drafted properly so that if they get another job, they're not getting an extra bonus by you paying them all this 3-6 months notice in lieu, and then they get work elsewhere? Can you claw anything back? That's possible. Could be managed also in a settlement agreement that way, potentially, depending on the negotiating position of the parties. What happens to bonus and benefits during the notice period as well? That's something that we really need to handle carefully. As I indicated earlier, if you don't manage that properly and you don't honour your either implied or expressed commitments to provide bonuses and benefits as appropriate, you could be in breach. And we always go straight to, if it's commercially sensitive and it's a key person, the covenants. So we prepare these a lot for clients. We also review them a lot for clients to see whether they apply. This is one of the first things we get our heads into legally, along with the notice, and as we'll see, the basis for dismissal as well. And if they are valid, great. We need to be incorporating them into any deal, so they need to be referred to in any settlement agreement or any proposal, and we'll look at that later. If they're not valid, then we need to be thinking about how we can incorporate new protections in and or pay for new protections as part of negotiated exit. And then also things like handing over work and so on. So we're not going to push the button yet. We're just looking at the terms and timing and how the notice might work. But some contractual provisions that we prepare will allow us to put someone else alongside, or and will give us some room to manoeuvre there. And do you need to do that? And will garden leave work while someone else takes over? And that, all those considerations around what to do with the staff and the customers and the systems and the information that we want to protect and how we can either work with this person as a negotiated exit or get them out of all that on garden leave. These are all considerations that we want to think about carefully before we go forward. But whether or not we can trigger all that, whether or not all of that is going to be useful to us, and how we go about it will really depend on the basis for our removing somebody, because the basis of removing somebody dictates your strategy very much. So we're just going to move on and look at the basis for dismissal, I think, on the next slide, aren't we, David? I think that's right.
Yeah. So as Lee was saying, the starting point really is to look at what is the potential reason for termination, the basis for terminating the director's employment and directorship, and the possible claims that arise from that, and that needs to be nailed down from the outset, because it then dictates the strategy that you're going to follow from there on in. So it's important to nail down that reason right from the outset, and also before you do anything else, look at the potential claims that may arise depending upon what determination you've come to in relation to the basis for termination. So just look briefly at some of those. So firstly, there are unfair dismissal claims that potentially arise, and listed under there you'll see the main potential fair reasons for removing an employee from their employment. And you've got gross misconduct, poor performance, redundancy, and some other substantial reason. There is another one, but it doesn't normally apply certainly to directorships. It's essentially illegality, which would not normally be an issue with a senior director. That's why we've not really dealt with it there. But so those are the main reasons. And if we just look briefly at them, gross misconduct tends to be quite rare for directors, but it does happen. For example, if you've got somebody who's a director that's defrauding the company, dishonesty offence would generally be gross misconduct. Assault is another one. So some obvious ones. So they're quite rare, but you do sometimes get issues of gross misconduct, which give you the right to terminate summarily without notice. Less common that in certain director service agreements, there may also be provisions whereby you can summarily terminate upon the occurrence of certain events. For example, if a director is disqualified as acting as a director, in some service agreements it will provide that that's grounds for summary termination, or criminal conviction for a dishonesty offence can be another thing that you often see in director service agreements. And obviously, that does give you the grounds to terminate summarily. Doesn't necessarily mean that you won't get an unfair dismissal claim. So you still need to follow a proper procedure, a fair procedure, and comply with the ACAS code in relation to disciplinary issues. Because if you don't, you're likely to get an unfair dismissal claim, even though you may not have a breach of contract claim, because you have the contractual right to do what you've done. Poor performance. Touch briefly on that. It's more of commonly a reason for wanting to exit a director than gross misconduct, but it's also more difficult in many ways, because it's difficult to do it quickly, and often with directors, once you've reached that decision and you reach the decision that you want to exit them, speed is generally one of the main issues. You want to get on with it for commercial reasons. But performance, in terms of dismissing somebody fairly for poor performance, is not a quick process normally. So we'll talk about settlement agreements later, but it tends to be one of the things that pushes employers more towards exiting via a settlement agreement, just because of the time involved in dismissing somebody fairly under a performance process. It's not quick and easy. Redundancy, a bit more straightforward, tends to arise in restructuring type situations. So there might be a merger or takeover that results in a particular director's position no longer being needed. And again, that can be done reasonably simply, provided again that a fair and reasonable procedure is followed. So the essence of a fair redundancy tends to be plenty of notice, consultation, and obviously consideration of possible alternative positions within the business. But provided that's done properly, then that should be reasonably straightforward. We'll put some of the substantial reason in there as well, which covers things like personality clashes. So it doesn't necessarily come under any of the other reasons, but it's the relationship with a particular director can sometimes become simply unworkable. There can be irreconcilable differences between board members, and it's simply not tenable for it to continue. And that doesn't obviously fall under conduct or performance. It can just be just a fact that certain people don't get on with each other, and the differences are irreconcilable. It shouldn't be used as something, as a convenient sort of label to avoid you pinpointing what should really come under one of the other reasons. So tribunals don't particularly like it, because they like employers to nail down one of the other reasons if they possibly can. But there are certain situations, like the ones I've referred to, where it can be valid and it can be a potentially fair reason. But again, procedure is important. Follow a fair procedure in order to avoid unfair dismissal claims. Other claims that can arise, contract claims. The main one that tends to arise here is for breach of contract is wrongful dismissal. So Lee's already mentioned the provisions about notice. It's important to get that right in order to avoid falling foul of breach of contract claim and potential wrongful dismissal. I mean, in terms of value, they tend to be limited to the notice period. Obviously, if you're talking about wrongful dismissal, the remedy is essentially claiming what the employee would have received had they been paid the correct contractual notice or worked the correct contractual notice. But with senior directors, that can be quite significant, because obviously the notice period can often be 6 or 12 months. So they can amount to quite significant claims. And again, without proper drafting, these can be significant claims, because you can also get into areas where bonuses potentially can be brought into it, depending upon whether the contract's been well drafted and whether you've dealt with the exit properly and whether you've actually complied with what it says in your contract in relation to dealing with notice. So they can get complex, and they can sometimes be quite high value claims. The other thing that's sometimes overlooked with them, they can also feed into claims in relation to shares, which I'll come on to later. I've dealt with cases where an employer is dismissed for gross misconduct and hasn't paid notice, when in reality it wasn't really a gross misconduct issue. And I think they've done it on the basis that they thought they were just risking essentially a wrongful dismissal claim. In other words, it was going to be limited to the notice period, and completely neglected to consider the share issue, which there were good leaver, bad leaver provisions in the shareholders agreement and the articles. But they didn't allow them to. They weren't allowed to treat this particular employee, the example I'm thinking of, as a bad leaver without if the employee was found to be wrongfully dismissed. So that was an oversight. So you need to look at not just the immediate issue for breach of contract, but does it have any knock-on effects on any other issues, such as shareholding entitlements, etc.
So that would be, is that the case then, David? Then it's checking to make sure that exit satisfies the bad leaver provisions. And
yes,
if it doesn't, then you're going to have to negotiate, aren't you?
That's right. And the example I'm giving, the employer was concerned mainly about the risk of the risk of an unfair dismissal claim. I think in the particular instance I'm thinking of, there wasn't sufficient length of service for this to be an unfair dismissal claim anyway. So I think the employer just took the view that the worst case scenario is this particular employee may bring a claim for wrongful dismissal, in which case we'll just have to pay them the notice. Yeah. So we may as well risk that, because we can either pay the notice now, or we can pay it if the employee brings the claim. And they hadn't considered that whilst the employee may be a bad leaver if dismissed for gross misconduct, if they were found to, in this particular example I'm thinking of, if they were found to be wrongfully dismissed, i.e. in breach of contract, they haven't been given the notice, then they would begin to be a good leaver, and they would get full value for their shares, as opposed to nominal value for their shares. So in that example, obviously it made a huge difference. So so that's an example, really, I think, of not taking a joined-up approach and not considering all the relevant documents that Lee's alluded to before. You need to look at everything and see how it's all going to fit together, because you might think you're safe on one claim, so you might be fine on your unfair dismissal. You might not be particularly concerned about your wrongful dismissal claim. But if you neglect to look at the provisions about shareholding as well, then you could potentially have overlooked a hugely valuable claim that could have a massive impact on the business.
You don't want that coming
no,
back.
No, so it's it's an example. Really, it's a good example to illustrate the importance of having a joined-up approach and making sure you consider everything in advance. So other claims, obviously, there can be Equality Act claims as well. So you need to consider that. Equality Act. We're talking about discrimination claims. So if an employer an employee, an exiting director can make a claim that the reason for termination was associated with a protected characteristic. So, for example, age, sex, disability, race, etc. If they can make out a claim that the reason is connected in some way to one of those protected characteristics, then you could face a discrimination claim. So again, it's important to follow a fair procedure and to document everything carefully to make sure that the reason or reasons for termination are clearly set out, and you can clearly justify the termination and demonstrate that it wasn't for any reason connected with the protected characteristic, because there can obviously be quite significant claims, because the employee can claim not just financial losses but also injury to feelings, and importantly there is no cap on discrimination claims. Public Interest Disclosure Act claims are also mentioned there, so whistleblowing we're talking about there. So again, before you make the decision to pull the trigger on dismissal, particularly with directors, because they're switched on to this sort of thing, because they're dealing with it in the day-to-day jobs very often, so they're dangerous dismissals from that point of view. And they will also have access to lots of information.
And advice probably as
yes,
well.
And they'll have been involved in lots of conversations at different levels in the business. And so what you need to be really looking at here is there anything that this director can point to say, essentially, I've made a protected disclosure, and then link that disclosure to the subsequent dismissal. So anything that pertains to a potential breach of a legal obligation that has a wider impact other than just on the director individually. And so, for example, if the director, I would just think of an example off the top of my head, if a director's flagged up a health and safety issue, and flagged up concerns about that possibly at a board meeting, they might try and use that and say, well, the reason for dismissal is because I flagged up this health and safety issue. I think it's a protected disclosure, and the reason you're exiting me is for that reason. And it may be nothing to do with that, but it's and it probably isn't nothing. It probably isn't anything to do with that, but it doesn't stop them making the allegation. So you've just got to be aware of anything like that and make sure that you've got everything ready to counter any arguments like that may be put forward. Shareholder claims, I've mentioned that. I won't really say too much more about that other than just to make the point again that you need to check your articles of association and any investment agreements or shareholders agreements that have got hopefully got mechanisms in place for exiting a director stroke shareholder, so that there are clearly documented procedures to help you deal with that, and also it feeds into the reason for dismissal again. To go back to the good leaver, bad leaver provisions that you commonly see in articles and investment agreements, you need to make sure that, because they are all different, they vary quite significantly between companies. You need to make sure that whatever reason you're pinpointing for dismissal sort of dovetails with how you want to deal with the exit as a shareholder as well. Because if it doesn't, for the reason, the example that we gave before, that can be a major issue for an employer.
Great. Okay.
I think that probably covers that.
Super. Yeah, thank you. That's fantastic. So I'll just move on to the next slide for everybody. So we've looked at, again, it's an overview, but as David outlined clearly there, when we come in for you and when we make these assessments and when you're looking at this to prepare the way, shall we say, you're looking at those legal bases for claims all the time, because they create leverage on both sides. So leverage for, and this goes nicely onto the process, which I'm going to talk about here on the slide. Not only do they dictate, your potential risks and liabilities, but they also dictate, this is the potential claims, the process you can follow. And they also, I think, really importantly, provide an assessment of the strength of the parties' positions, and that obviously reflects how good the offer is. or good the offer needs to be if you're going through an informal commercial settlement agreement, shall we say, and not informal, shall we say, a commercial exit. So, for example, if there was a whistleblowing, a protected disclosure that the individual's got a credible argument, we're going to have to factor that in to any process that we exit them through. If there is definite poor performance or gross misconduct, then we're probably more inclined, aren't we, to go through some form of process that uses that as our leverage to remove them. But the question often is which process is most appropriate. Now, I think David put his finger on it perfectly, which is most cases of senior executives or directors is get them out as fast as possible. So what we tend to do is, yes, you can follow, as David mentioned before, gross misconduct. There will be the ACAS code you've got to follow. That can be very contentious. The more time you give a sophisticated individual with lots of access to information, the more problems they may cause you. But, if we've got good evidence of gross misconduct and it's clear, then we can move forward with it. But then we go back to our original considerations. Is that a PR issue? Do we want this out in the open, or would we rather deal with it privately through a commercial agreement, a settlement agreement, for example? So there are lots of considerations as to which process to follow. I would generally say, though, that the formal process tends to be dealt with where you have really clear evidence of, for example, gross misconduct, poor performance, even SOSR potentially. You go through a more formal process when you're not worried about team disruption, effect on PR, customers and the business. Okay, or there may be a point of principle that you want to put that person through that process because of what they've done. Sometimes clients want to do that. In most cases, though, clients want to deal with this on a commercial basis for various reasons, and those reasons usually are minimum disruption. I can control their access to customers, staff. I can control a handover. I can get all this information back, and I can negotiate a package. And what I think on this slide, rather than go into the details of a formal process, because I think the people who will be listening to this will be more than familiar with the kind of processes that you would need to go through for each head of dismissal, gross misconduct, redundancy, and so on. I think what I'll do is I'll just talk about how we handle the commercial options, because I think they're often the most relevant in these cases. So once we've assessed the situation and we know what our leverage is, we know what their leverage is, the potential claims, the information, the package, the equity, bonuses, notice, everything else, what we tend to do is put together usually a protected conversation, or if we're already in dispute, it might be using without prejudice. And I won't go down that whole discussion, but there are two sort of means for approaching an individual depending on the circumstances, and approaching them in a way that, generally speaking, that approach can't be used against us. But I would just say this: if you are thinking about doing a Section 1A protected conversation and making a proposal and package to somebody, or without prejudice discussion, you need to know on what terms you're doing it, and you need to make sure that it's valid legally, and also what's in it can't be used against you, because it still needs to be prepared very, very carefully. Any proposal, basis for proposal and package needs to be prepared to fit with all of this that we've talked about, to cover all these bases. But also remember that you can't hide everything in those conversations and those proposals. So, for example, an act of discrimination could be disclosable, or if it was used inappropriately and not in the right way and right process, that's the head of, say, protected conversation, it could all be disclosable potentially. So I really do tend to urge clients to get some advice on that, in terms of how you're putting that proposition together and what cover you're using legally to make it. But what we'll often do is then put a package together, make a proposal in the right way, all pre-prepared in principle for the individual to consider. And during that period, you then manage the situation with them in terms of taking some extra leave, getting some advice and negotiating a package. If, again, going back to the basis for the termination, if your leverage is really strong, then often individuals are asked to go home, given a package, and it's done pretty quickly, because the stronger the evidence surrounding any allegations, for example, of gross misconduct, the more likely it is we'll have the upper hand in the negotiation, and we'll be able to factor that in. The pros of doing a managed exit like that are you can get everything ready. You can get the package ready. You can list all your confidential information, all the customers, all the covenants, everything you want to manage this exit, requirements for the individual to hand over, property, everything else. And it can be budgeted, costed, negotiated, dealt with, signed up to, and you can replace the individual quite quickly with announcements, references, etc., all organized. So most businesses at this level want to follow that kind of process, but I must stress that process really can't be followed confidently without going through everything else that we've gone through and assessing it carefully. We do see a number of examples where clients have pushed the button too quickly, and say, for example, in David's case, and we've had a number of cases dissimilar where things like equity interest, or a recent one that springs to mind for me, bonus provisions weren't dealt with properly. Then we're dealing with claims that are worth best part of $500,000 or even more in either equity claims, share claims, and still disputes over share value, because shares haven't been able to be transferred. There's still post-termination negotiations and claims, and also bonus values as well. And that's just a couple of examples of things that can bite you if it's not dealt with properly. So think about it carefully. The legal leverage and basis for claims and the basis for the exit will dictate the type of process that you're going to be able to use, and then that's where you really, I would stress, legal advice is needed. And we're obviously super happy to help if anybody wants to get in touch. So final bit of this talk, David's just going to flag a little bit, I think, just highlights on removing director and shareholder rights, which you've touched on already a little bit as well.
Just in relation to company law considerations, and in particular how to remove the director from the board, and this does need to be lined up carefully with dismissal as an employee. Because what's often overlooked is that they're not one and the same thing. They are separate things. So if you terminate an employment contract, it doesn't automatically bring the directorship to an end. And that's important because if the individual that we're concerned with is still a director of the business, then they have certain entitlements. They're entitled to sight of company records. They're entitled to be informed about the company's affairs, and if they're not so informed and they're not given the information they're entitled to, then that can affect the validity of decisions that are made at board level. So you don't want somebody exiting as an employee and then still being a director, because that causes all sorts of problems. So it needs to be lined up so that both things come to an end at the same time, or sometimes the directorship may come to an end before the employment, but you certainly don't want a directorship continuing after the employment has ended. So often in the service agreement itself, there will often be a provision in there, commonly, that if the directorship comes to an end, that they agree that their employment will end, and sometimes it's the other way around as well, so that there may be a provision in there that when the employment comes to an end, they agree that they will submit their resignation from any offices that they hold, including directorships. And that would often be in the service agreement, but not always. So you need to check that. Another reason to check the documentation beforehand. And the other practical issue is, even though it's in the agreement, they may not necessarily comply with it. So we've at least talked about settlement agreements and the advantages that they have in terms of dealing with things quickly and commercially and in a controlled way. Well, this is another example where a settlement agreement can be very useful, because you can put in as a condition of the settlement agreement that the director will resign, and there will often be in the settlement agreements that we deal with, where this crops up, you would basically have a director's resignation letter appended to the settlement agreement as a schedule. And it would be a condition of the settlement agreement that they also sign that resignation letter at the same time that they sign the settlement agreement, so that it can be dealt with, and you can file that, and you can obviously make the appropriate filings at Companies House to make sure that they're removed as a director. But often you do get situations where that isn't possible, because you can't reach an agreement. They simply refuse to resign as a director. So what do you do then? Well, it may be provided for in the articles. So there may be a provision in there that when employment is terminated, that they can be removed as a director, and that there may be a clear mechanism for doing that in the articles. But often that isn't the case. It's certainly not in the standard articles, and so unless you've had some bespoke articles drawn up, it's unlikely that that's going to be in there. Sometimes it is, but it's quite rare. So more commonly, the service agreement will have it in there, as I mentioned before, that you agree, or the director agrees, as when they sign the service agreement, that they will resign from any directorships upon termination of employment. But what if they refuse, despite it being in the contract? Well, hopefully, if it's been properly drafted, it will also have a power of attorney in it, which enables essentially the company to step into the director's shoes and deal with the resignation on behalf of the director, despite the fact the director's refusing to do it because they've got a power of attorney in the service agreement. So check for that as well, see if there is a power of attorney in there, and also check, even if there's a power of attorney, that may not be effective if it hasn't been executed properly. If there's a power of attorney in the service agreement, it needs to have been executed as a deed. So if it hasn't been executed as a deed, it hasn't been properly witnessed, then it may be in there, but it may not be effective. So check that again, so that you know in advance how strong your bargaining position is. And finally, if all else fails, there is obviously a provision to remove a director under the Companies Act by an ordinary resolution at a general meeting. But that does require a meeting of the members and 28 days notice. So it's not an ideal provision to be relying upon. You don't want to be doing that. And again, it gives more time for the director in question to cause mischief and avoid you resolving the situation quickly, which is generally of the essence when you're dealing with this type of situation.
Another argument for tying it all up in a settlement agreement, if you haven't had everything prepared properly at the start, you can tidy all these things up, which is helpful. Okay, is that, you covered everything?
I think that covers everything I wanted to say.
That's brilliant. Okay, well, I hope that is useful to everybody. Again, if you want to get in touch with us, we're really happy for you to do so, to help on these kind of issues, and we hope that was helpful. We'll be sending some more updates out on a more regular basis to our clients and partners, and also through our LinkedIn channel to all those that follow us at Bridge as well. So thank you very much.
Thanks very much.
Thanks for listening. Got that bit.
Finished.